do bring in immigration updates from Houston Live. We do take questions from 5 p.m. Central Time to 6 p.m. Central Time. Rebecca, what do we have today to discuss?
Yeah, so first we'll discuss the OPT program and its potential risks. The new USCIS director that's been nominated by President Trump has come out and said that he wants to eliminate the OPT program entirely. So we'll discuss what are the likelihood of that and how long it could be before something like that could be put in place. We'll also discuss the freeze on F1 and J1 visa appointments at the consulates. This was a recent directive to all consulates regarding F1 visa appointments in light of new expanded vetting procedures that they are preparing, especially for F1 students. We'll talk about the B2 change of status strategy that has been very useful the past few years for H-1B and other non-immigrant visa workers who find themselves laid off or with their employment terminated and unable to file a transfer or another application within the 60-day grace period. The B2 change of status we've talked about a lot. But the website that has that policy on it is suddenly archived. So we'll discuss whether that means the administration is considering reversing that policy and what that would mean for people who find themselves laid off in that situation. And we will also talk about U.S. tech companies urging their workers not to travel right now, which has also been our advice since the beginning of the year.
First thing, let's discuss about the OPT. This OPT is, if the administration does want to remove it, the STEM extension also they want to remove it, we know that. However, for them to remove the STEM extension, they may have to go through the regulations because STEM extension came through regulations. What does that mean is that the administration can eliminate it without going to the Congress. The parliament is called Congress in the United States. So without going to the parliament, they could get this STEM extension removed completely, though. But when it comes to the OPT, though, which is very unlikely for them to eliminate completely OPT through regulations, they may have to go to the parliament, which may be very reluctant to take the complete OPT off. However, the administration, through either regulations or some policy changes, may try to restrict the amount of the way that it's been used at this point of time. For example, there is a certain unemployment period allowed. There is unpaid internships probably may be allowed. So they may put some restrictions on the existing OPT going forward, though. However, for all these things to get the changes effective, it may take a couple of years for it to be effective. Can that administration try to do it fast? Yeah, they can. They try to do a lot of things very fast. For example, taking the citizenship off for those people who are getting born in the United States. We know what happened, where the court stopped it, at least for temporarily. They tried to remove the people who may have some kind of interaction with the police at any point of time, to remove all of them, terminate them from the civil system. We have seen that courts have put them back in, where the administration was forced to put them back into the civil system. We have also seen that they tried to terminate this Harvard University, which is a well-known university in the world. Approximately 6,000 students who are international students could have been affected if the civis has been terminated for Harvard. The courts have put it back. So if the administration tries to do it very fast without going through proper legal channels, definitely courts may interfere and put it back. That's what our estimate is right now. Any different version, Rebecca, on this?
No, yeah, and we've seen this before. There have been challenges in the past to OPT. There was that saga of the STEM OPT litigation The main difference there, of course, was that the litigation was brought by kind of a private an organization of U.S. tech workers that were challenging the STEM OPT rule. And that was a years-long lawsuit that kind of made its way and was ultimately unsuccessful. Of course, the STEM OPT rule is still here. The main difference in this case is that if there are attempts to eliminate it, it would be by the administration itself. But as Rahul mentioned, the basic one-year OPT is statutory, would require an act of Congress to change, and then the STEM OPT extension is regulatory, and as we saw from the lawsuit, would require kind of a pretty high threshold to overcome as well.
Going to the next topics, Rebecca, that you said that there is a freeze on the visas. When I looked into the memo that has been circulated from the Department of State, it looks like that the existing visa appointments will go through the old policy. That means that they don't have to go through the extreme venting policy of what the new administration has bought. But going forward, they have frozen. That means that they advise all the consulates to stop even giving an appointments to the F1 visas or J1 visas at this point of time. So if you are planning to travel, especially the J1 visas who are planning to travel and you have not made any appointment, you should not travel because you may not get an appointment for a long period of time. And if even you do, we need to look into how this new policy, whether granting the J1 visas or F1 visas, how will it be going forward? Will they take a lot of time when you apply? Will they increase the fees? Will you have to? I know that we have to all submit the your social media accounts, all the information about that. How much time the government is going to take to analyze the social media? Does it mean if you're in favor of certain activities, they are going to allow you? If you're not favor in certain activities, they're not going to allow you. We have no clue at this point of time what they're trying to do. But definitely, if you already have an appointment for F1, M visas, or J visas, you can go through the old policy. You should be okay at this point of time. But if you're trying to make a new appointment, on the student visas, though, you may not be able to make a new appointment at least in the near future. So we don't know if by August, that's when most of the students will come into United States. If by August, everything will be restored and they will start giving appointments. I have no clue at this point of time. Rebecca, any insight that you may bring in?
Yeah, it's hard to say. Historically, consulates have kind of prioritized F1 visa appointments, especially during the summer, because they know that students are, enrolled and expected to start the school year in August or September. With the current administration, we've seen that they are not in favor of F1 international students for whatever reason. And so we don't know how concerned they will be to prioritize those appointments once they become available. But yeah, this directive from the State Department to all diplomatic and consular posts was issued today, and it basically puts a freeze on any new F1 or J1 visa appointments being made available or scheduled at all consular posts worldwide. So as Rahul said, if you have an existing appointment already scheduled, it seems like you should be able to attend that appointment as normal. It doesn't sound like you will be subject to the additional screening or vetting procedures that are being prepared, but anyone trying to make a new appointment right now won't be able to. And when you are able to make the appointment, it sounds like there will be what they call an expansion of required social media screening and vetting, kind of meant to be consistent with the two executive orders on protecting the United States from foreign terrorists and other national security and public safety threats, and additional measures to combat anti-Semitism. So it does seem like the additional vetting and social media screening process will sort of be in line with some of the principles that have been causing F1 students here in the U.S. Problems already in the last few months.
Go to the next topic of the B2. We have been using B2 visas when people get laid off from H-1Bs. We move them B2 and stay here for 6 months so they can look for another job. In fact, USCIS in March of 2023 advised people, hey, why not you move to B2 when you want to, when you want, if you want to stay in the United States, look for a job, you can apply for B2 visas. And once we apply for the B2, we normally typically we file it online, takes about 2 to 3 months to get it approved. While it is pending or after it's been approved, we have seen that we can change to H-1B without any problem, had no issues at any point of time. This was the policy of Biden administration. What changes had this government has brought? Where did you observe those changes, Rebecca?
On the USCIS website. So these policy changes that were implemented by the Biden administration in 2023, it wasn't, a regulation or even a USCIS memo. It was just published on the USCIS website under the title Options for Non-Immigrant Workers Following Termination of Employment. And the option to change status to B1 or B2 is listed on there. The policy of kind of bundling the pending I-539 with the I-129 petition. When you do get a job offer later, that policy is listed in these Q&As on this website. So we have, as Rahul mentioned, been using the policies on this website very successfully for the last couple of years for people who find themselves in this situation. Recently, if you go to that website now, at the top, there is a message that says archived content, and it says the information on this page is out of date. However, some of the content may still be useful, so we have archived the page. We don't know exactly what information on the page may or may not be outdated. It just says the information on this page is out of date. We haven't heard anything from USCIS so far explicitly stating the B2 change of status is no longer an option, or the bundling policy of grouping a pending I-539 with the new I-129 change of status petition is no longer applicable. They haven't come out and said that necessarily, but by archiving this page and saying that the information on it is out of date, it may indicate that USCIS is kind of deciding to reverse this policy, which they can. If that is their decision, as we mentioned, this is just a USCIS policy. It's not, codified as a regulation or anything like that. So it is within their power to change at any time, and it seems like they may be doing so now. If you do find yourself in the situation where you are in the 60-day grace period and you are considering the B2 change of status as an option, I don't know, Rahul, do you think people should still go ahead with filing a B2 change of status right now?
Yeah, I think so. They should still file the B2 right now until we hear any denials coming or we see any change of status from B2 to H-1B getting denied. I don't see a reason right now to immediately change, because even after the denial, they can still leave the country and then safely come back in H-1B, because they will be accruing the out of status only after the denial of the B2. So I don't see a reason at this point of time to fear and run away. You know what happened with the F1 visas when the visa got revoked and they got a statement, you got to depart or you're going to be deported and you have to self-deport kind of things. And when these people self-reported, they found out they were the fools because they got stuck outside. The civis was reinstated by the courts. Definitely, I don't want people to take any immediate action. If you're considering moving into B2, if you got laid off, I still want you to continue. So definitely, I want you guys to keep coming to this YouTube channel every Tuesday. If you spend at least 30 minutes with us, because we'll update if there is any new development that comes on the B2.
And then for tech companies in the US, they have been advising their employees on work visas to not leave the country and not travel at the moment. We've also been recommending that, especially if you would need to get a visa stamp at the consulate before returning. So employers are also urging their employees to not leave the country right now. Rahul, do you have anything else to add for that?
These companies definitely are giving proper advice. They want their employees to be safe, working for them. And also, of course, they want the employees to be doing very good for them, for themselves as a family too. Definitely, if you are going for stamping, we advise people, don't do it at this point of time. The administration does not like you. They don't want you in. And people ask me a question that I am working for a big company. If you're working for a big company making a lots of money, they're jealous of you. If you're working for a small company and then you're not making that much money, well, they have another excuse to deny. So definitely, either way, we don't want you to go for stamping at this point of time. Um, Traveling, whenever you are wanting to travel, definitely get an advice from the lawyer to make sure, evaluate it. Is it worth for you to take the trip? Is it worth for you to take a risk and get stuck there? Because if some things you get stuck there, it's going to take sometimes years, and sometimes you may not be able to come back because the job won't stay there for you. If you leave the country and they issue 221G, and then by the time they resolve that thing, you lose the job. When you lose the job, you will voluntarily have to withdraw your application because you don't have a job. So all these things are things that will affect you. We definitely don't want you to travel. And I tell people who are going for stamping, no, 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 no. Don't go for stamping. Just stay here, stay put. That's what I strongly recommend. Obviously, the bigger companies, I have to agree with these bigger companies when they're advising their employees not to travel. Very good advice they're giving. Anything else before we go to questions, Rebecca?
No.
I have some question. Nash is asking this question. Why don't you update me about if people have gone to biometrics, as people have noticed that recently, if there is any interaction with the police or any untoward incident that may have happened with them, like for example, if they have not paid the parking ticket, missed out the made the parking ticket a little bit later than what is required. Um, we have seen them getting called for the biometrics. This didn't used to be there. They were just asking the employer to respond saying that, hey, we have some adverse information on the employee, and so we want to have the home address of this guy. Well, it's already provided on either H4 or it's provided on the H1B or I-140. All those things were already provided. I don't know why they're asking. So when we are providing them, they're issuing a biometrics. No update at this point of time. We have not seen anybody getting detained, definitely not. We have not seen anybody's H1B, H4, or I-140 getting denied because they have some issues. But Nash, we want you to follow us continuously every week. We will update you next week on this topic again if there is any new development. And if there is any sudden development that pops up, we do issue a bullet. We do normally come up and advise people. So if you subscribe to our YouTube channel, if you subscribe to our R-in-law group news blog, though, you will get the information as soon as possible so that you can arrange whatever you have to do at that point of time. Now, there are some people that have some major criminal issues, for example, drug kind of issues. Now, that's different. The advice that I told you is not for it's not for those people though. I'm only speaking of those people who have some minor criminal issues, but not major criminal issues. Major criminal issues, we have seen them. There are some cases where they have detained. But for DUIs and some small little things, we have not seen any denials, detentions, or extension denials. We have not seen them.
Dilip Kumar is on an L1 visa, moved to the US in L1 status about 6 months ago, and asks, is there wait time before I apply for EB1? And also, do I need to depend on my company to file it, or can I just apply for it with an attorney on my own? So there's no wait time to apply for the EB1C category. So if you have an approved L1A, you most likely are qualified for EB1C. There are a couple of small differences between L1A eligibility and EB1C eligibility, but for the most part, if you recently had your L1A approved, you are most likely eligible for EB1C. And yeah, there isn't a required amount of time that you have to be working in the US before that EB1C petition is filed. So you could get started on it right away. However, the EB1C petition is an employer-sponsored petition. You do need your company to be willing to file the I-140 on your behalf for EB1C. And so you won't be able to do it independently with an attorney. There is the EB1A category that does allow you to self-petition. You don't need an employer sponsor for EB1A, but that category is for extraordinary ability, and you're most likely going for the EB1C if you're a multinational manager. So I would discuss with your company, see if they can start the EB1C process, especially if you're from India. EB1 is also backlogged right now by a few years. So the earlier that they can start the EB1C petition and get it filed and get your priority date locked in, the better.
The questions are coming from Satya, whether you see that advanced parole, is it safe to travel? Also, I've seen some people asking green card holders, is it safe to travel? Absolutely not a problem for advanced parole people and green card holders. We haven't noticed any problem for them when they traveled outside the country. We haven't not seen that at all. And if we do at any point of time, we will inform you. But as of now, no problems, none whatsoever at all. We are assuming that your travel will be less than 4 months, that you leave the country and come back. And in the advance, if you're an advanced parole, this is not for the green card holders, it's only advanced parole. The main applicant definitely has the job when you are traveling outside the country. I'm assuming that all these things is true, then I don't see any problem in you traveling. For the green card holder, you don't have to be employed. Even if you're employed or not employed, it doesn't matter. You can travel, but definitely I'm thinking that your trip will be less than 4 months. If by any chance your trip is more than 4 months, definitely we want you to consult an immigration lawyer before you take any steps.
We have a question from someone asking, is it advised to apply for TSA Global Entry while you're on an H-1B or H-4? So actually, we have seen a lot of issues with people who are on work visas using Global Entry or Nexus kiosks recently at the port of entry. Theoretically, you should be able to update your Global Entry or Nexus account with your current visa and your I-94 number, and then when you go in through the kiosk, it's supposed to update your I-94. So at every entry, you get a new I-94. When you go through Global Entry, it's supposed to know that you are coming in on H-1B status and will issue you an I-94 in that status. We've seen a lot of issues though with people using Global Entry or Nexus where the system issues them an I-94 for a visitor status instead of their work visa, even when they have gone into their account and linked it to their work visa. So something's going on with the kiosks. They're not always reliable. Everyone, no matter what route you're taking, you should always check your I-94 online after each entry to make sure it's accurate. The problem is if it does issue your I-94 in a visitor status and you are not aware of it, you haven't checked your I-94 for several months, you may have been out of status or working without authorization for several months if you just, resumed working when you came into the US because you're not authorized to work on a B1 or B2 visa. Just to be safe, we've been recommending that people don't use those kiosks if you're on a work visa and you need an I-94 that specifically has your non-immigrant visa class on it. Just go through the line and show your documents to an officer and still double check it after you enter to make sure the information was entered correctly. If an I-94 is incorrect after you enter the US, there are ways to fix it, but they are getting more difficult. CBP is just getting more difficult with everything. It used to be that you could email any deferred inspection port of entry and get an I-94 updated relatively quickly, maybe after a few days. We have tried a few times this year, and it has already gotten much more difficult under the current administration to get I-94s updated through email with deferred inspection. A lot of ports are now saying, we will only do it if you enter through this port or if you live in this area. So try not to do anything that would increase the chances of a mistake on your I-94.
Any update on the H4 EAD? Are they planning to remove or leave it alone? Definitely, this question is coming from Naveen. Definitely, they want to remove it. So we need to see how they have to come up with the regulations, though that may take a little bit longer time for them to remove it. But definitely, Stephen Miller, the advisor on immigration for the president of Trump, said is very clear that he doesn't want H4 EAD.
We have a question from someone asking, can you change your status from H1 to E2 without leaving the country? If so, how long can I stay without leaving the country? That is possible. One thing to make sure of is that in order to be eligible for the E2 investor visa, you have to be a national of one of the countries on the E2 treaty investor list. So as long as you are on that list and have a passport from one of those countries, if you invest in a business or have started a business and are eligible for the E2 visa, you can file for a change of status by filing an I-129 petition with USCIS, and you have your status changed without leaving the country. A couple things to make sure of: you would most likely need to do that within the 60-day grace period, potentially after your H1 employment ends. Unless you have a business partner who is doing a lot of the groundwork with setting up the E2 business, because you can't really be doing the initial groundwork while you're on the H-1B visa. But that groundwork needs to be in place. You have to show that you've invested a substantial amount and that there is, marginality and, all of that for the E2 visa has to be in place by the time you file it for the end of the 60-day grace period. So you have to prepare and plan it pretty carefully if you're going to do it as a change of status. Another thing to keep in mind is that if you do leave if the E2 change of status gets approved, you'll be authorized to remain in the U.S. in E2 status for 2 years. But if you leave the U.S. at any time during those 2 years, you will need to apply for an E2 visa at the consulate, most likely the consulate in your home country. And at the consulate, they won't just take your E2 approval notice from USCIS and just grant you a visa based on that, the way that they do with the H-1B. The consulates are going to do their own independent review of your E2 visa application, which means you have to submit a whole application package to the consulate, which, depending on the consulate, each one has different processes for E2 submission. It could take months. You might have to email it to the consulate months before you can actually schedule an appointment to go in for the E2 processing. So just make sure you consult with an immigration attorney before doing that.
Some rumors are flying out, Rebecca. Faz Rafi is saying that a 60-day grace period, is it allowed or is it not allowed? The website of the USCIS, after he mentioned it, I looked into website of the USCIS, and that's been archived too. It's not there anymore. However, it is a regulation. It's in the CFR. It's in the regulation, the 60-day grace period. So they can't just do it on the website. They can't change it. It has to go through the regulatory policy. So the 60-day grace period still is there, will be there. If they want to change it, they have to change the regulation. They don't have to go to the Congress, but they could do it. And the changing of regulation takes a lot more time. So at this point of time, if you lose the job, you do have the 60-day grace period. You can apply for the B2. Now, we don't know in the future if they are going to approve the B2 or they're going to create any problem for the B2. That's a different issue. But at this point of time, you still have the 60-day grace period according to the regulations, though.
Santosh is asking for his wife, who is planning to switch from an H4 to an F1 to do her master's, and is asking, is it better not to do a master's in these kind of unpredictable situations? So your wife is authorized to attend school in her H4 status. She doesn't have to be an F1 status in order to enroll in school. She would need to be an F1 if she is planning to get OPT or STEM OPT after graduation. So that could be a reason to switch to F1 eventually, but she doesn't need to do so right away. So if she is wanting to move to start her master's program, she could potentially just start maybe her first year on H4 and then kind of gauge the situation and what the state of the F1 and even the OPT is by then, because it sounds like the administration is going to try to eliminate OPT. If they have put OPT on pause for some reason, or the STEM OPT on pause, and that's what she was, aiming for, she may decide to just remain in H4 to finish her degree, or she could switch to F1 at that point, especially if she is planning any travel in the next year or so. So that she can travel on hopefully an existing H4 visa, not getting a new visa. But then, because once she changes to F1 status, going for visa stamping is going to be much more difficult, like we mentioned at the beginning of the hour. So she can start school in H4, maybe time the F1 change of status for a bit later in her degree program.
Couple of questions on the green card, people traveling. Some question comes on green card travel. Green card people, can they travel internally within the United States? Absolutely not a problem. A question that came from Shivam, that he recently on green card went outside the country for 30 days. It was last year actually, and he doesn't find the I-94 record online. Will that create any problem in the naturalization? No, the I-94 is not applicable to you. You won't be given I-94 now. You're a green card holder. It does not create a problem, none whatsoever at all. Since your travel is within 60 days or within 4 months, absolutely not a problem. Question from Rishma Pavarkar. Is it okay for the GC holders to use the global entry? We don't see any problem in the GC holders using a global entry. As Rebecca has pointed out, she has some issues when people who are on non-immigrant visa who wants to travel on global entry. But as far as the green card holders is concerned, we have no problem, none whatsoever at all, for you to use a global entry.
Daddy is asking about an H4 application that was filed with an old H1B receipt notice, and is asking, will the H4 extension be issued based on the new H1B approved dates or the old one? So USCIS can only issue the H4 end date consistent with the H1B end date of the receipt notice or approval notice that was submitted with that I-539 application. So if that I-539 is still pending, but since then the H1B has gotten extended again, and that H1B extended approval notice or receipt notice was not included with the pending I-539, you should go ahead and file a second I-539 with the extended H1B approval, because when the current one gets approved, it will only be approved till October 2025, for example. If you now have an H1B that's valid until October 2028, by the time the I-539 gets approved, it may already be past October 2025, and you don't want the H4 spouse to be out of status. So go ahead and file another I-539 application with the most recent H1B approval notice if that wasn't included in the current pending I-539.
A question that came from S, if the H1 person loses and that person loses a job, the person is married to another H1B person, do you advise moving to B2 or H4? Absolutely H4, not B2 though. If the H4 option and B2 option is there, go for H4, because H4 is a long term. And even if the government changes any policy on the B2, then you are definitely in a good shape. So definitely B2 is not an option for you. Messi Reddy is asking this question. He has some issues about the job. Which is a better way, consular processing or change of status? I'm assuming that this is about the H1B lottery that he got picked up, which he needs to file by June 30th. Absolute answer is only one thing, which is change of status. Do not go for consular processing because it's technically not counted to the H1B. If you want to discuss, you can consult with an immigration lawyer, but I would emphasize that it should not be consular processing. It should be change of status.
Amin is asking if he is on an EAD based on a pending I-485, can he start a business? Or should he keep the same sponsorship for his green card and start the business also? So when you're on the I-485, the I-485 is pending, you are required to have at least one full-time job offer that is in a position same or similar to the one in your approved I-140, your original underlying I-140. If the business that you're starting is going to be able to support that full-time job in that same or similar occupation, technically that's possible that maybe that can be the job offer. But if it's a startup from scratch, it's unlikely that it's going to support a full-time job offer right away. So I'd recommend probably to keep at least one full-time job, either with your I-140 original I-140 petitioner, or if you've moved to another employer since then, to keep, one full-time job in that same or similar occupation. And then if you're using the EAD, you can on the side, in addition to that full-time job, start your own business and start a company. And, eventually if it gets operating to the point that it can support your full-time job offer, you can maybe switch over to that full-time. But if it is just a brand new business right now, I would say probably you should keep your full-time job with an employer in addition to starting the business.
A very good question that came here is that in the perm application, if some qualified people apply for the job, does that mean that the labor certification is completely doomed? That the labor certification cannot be approved? This question is coming from very tough name, Uncles EG, whatever name it is. Anyway, no, just because the qualified individual applied for a job does not necessarily invalidate the perm process completely. The individual must be willing to take the job. So normally, just because a person applied for the job, you have to interview that person in the interview. After the interview, if the person wants to join the job, and if the person wants to join the job, and if the company does not want to hire them, then at that point of time, then the perm process cannot proceed any further because the recruitment failed. So not only that they have to apply, the eligible candidates apply, they must be willing to take up the job. That's when the perm process and the company does not hire them. So, for example, if they have positions that they can hire, and yours is one of the positions, and there may be more positions, and they want to hire that guy, on top of that, they want to continue with the perm process, they can. They can.
We have a question about perm processing times. Currently, I think we're still seeing about 15 months, and we're not expecting it to get any better. You can always check our website for articles. A member of our perm department pretty regularly posts an article about the most recent perm processing times once they are published by the Department of Labor. So you can always check our website there for the most recent processing time updates, but it is around 15 months currently.
People are asking whether the 60 days is cumulative. That means that do you get the 60 days for moving from company A to company B and company B to company C? So if you use 30 days, next time will you only get 30 days or will you get 60 days? It's between each company. Company A to company B is 60 days. Company B to company C is 60 days. Company C to company D is 60 days. It's not one time you use the 60 days, it's not over. It's every time.
So we have a question from someone who recently filed their B2 application, and they're asking, with this new update, can they still continue to stay and look for a new job? So I would say yes, if your B2 application is already filed and pending. Again, it is still early. It was just, I think, over the weekend that this archiving of this policy website occurred. So we haven't heard of any B2 applications being denied or anything like that yet. But if you do have a pending I-539 application in this situation, say, try to get your change of status back to H-1B filed as soon as possible. And also just, I guess, be more prepared than you were before to potentially depart the U.S. if USCIS does start issuing denial notices of B2 change of status applications based on this website change. Just be prepared to depart, pretty soon if you do receive a denial notice.
A question from Ayush Saxena. He got his EB-1B approved from company A. So he is planning to move to company B. How difficult is it to get an EB-1B approved? EB-1B is given to the company. It's not given to individual, though. Unlike EB-1A, which is based on your complete ability. So definitely it's another big hurdle to get an EB-1B approved again with company B. Now, if you can, I mean, his prior date is not current. He hasn't not filed the 485. Now, under these circumstances, since you did not file the 485, though, I would strongly recommend, urge you not to move out of the company if you possibly can. Even if somebody is going to pay you $200,000 more per year, I will tell you not to move. Just stay where you are. Even if it's, for me, even if it's $300,000 more, I'm not going to move out of the company. I don't like immigration lawyers. Believe me, guys, it's not good to deal with us all along, all your life, not good at all. And to get rid of us, EB-1B, you got it approved. That's very good. Your priority date is backlog. I understand it. Have more patience. Otherwise, you will have to keep coming to this channel for the next 80 years. You may have to. Not good for you. I won't be there, but my younger lawyers like Rebecca, they will be there. I won't be there, but it's not worth, guys. If you stay, you can get rid of his with the same company. You can get rid of us in very short period of time.
Dinesh is saying that his I-797 is still valid, but the I-94 of his spouse is expired and is asking, is she out of status and how can I get this fixed? Yeah, if your spouse's I-94 is expired, she is out of status. So you do need to check. So some people get kind of confused between the online I-94 that is issued by CBP and then the I-94 that's attached to the I-797 approval notice. So when you file an extension application with USCIS and it gets approved, the I-94 arrives as an attachment on the original I-797 approval notice. The online CBP I-94 does not get updated when your USCIS application is approved. The online I-94 only gets updated when you leave the country and come back in. So if your spouse has filed an extension application before her online I-94 expired, and that's either pending or approved, she is not out of status. But if her online I-94 is expired and an extension application was not filed before that happens. The most common situation that happens is when the passport expires before the H-1B visa holders H-1B end date, for example. CBP will usually cut short an I-94 based on the passport expiration. And if people aren't checking their I-94 right after entry, they may not be aware of it until after it expires. In that situation, you definitely need to speak with an immigration attorney as soon as possible so that they can see how long the I-94 has been expired and kind of assess the options at that point. If it hasn't been too long, usually what we do is file an I-539 extension application and include the nunc-pro-tunc argument, which is basically asking USCIS to excuse the late filing in their discretion. And typically they are pretty lenient with excusing a gap in filing for H-4 spouses, especially if it is due to that passport cutoff, because it is kind of an administrative thing. But yeah, just consult with an immigration attorney as soon as possible.
A question from Yuan. Yuan's visa was been revoked. This is between March 29th and probably April 10th or so. The CIVIS has been terminated. Of course, the CIVIS has been active right now. Can I file the STEM extension? Yes, you can. There are chances that you may get an RFP. Definitely, you may file the STEM extension, and if there is an RFE though, definitely you should use an immigration lawyer to respond to the RFE. They may even call you for the biometrics appointment because you have some kind of interaction with the police at one point of time or law. So definitely that's a caution that you need to take into. Ruchi Khanna has this interesting question. She's speaking about 204I. This allows for the widow or widowers to take advantage of their former spouse's I-140 application. In this case, that particular person is the spouse, I don't know about her or somebody, she may be asking for some of her friend. So the husband died, and the priority date is 2016, and this particular person is on H-1B, and her priority date is 2024. The husband was not working for the company that filed for the POM in 2016. Her question is that when the priority date of 2016 becomes current, can the spouse who is surviving use the priority date of the husband to file the 485? This is called 204I section. The answer is yes. The husband does not have to be working with the same company that filed for the POM in 2016. Now you get an independently filing the application, so you practically don't have to you don't have to get any approval from the company that filed the 2016 I-140 approval. You can file the 485 when the priority date becomes current. Now, one thing I want you to make sure is that you have to maintain the continuous residence in the United States. You did tell me that you are on H-1B, which is very good, that you're staying here on H-1B. You have to continuously stay here on H-1B or any other non-immigrant visa here to obtain the benefits of the 204I section, though. You can have a brief travel outside the country. That means you can go visit India for a month or two and come back, not a problem. But you should stay in the United States and visit other countries to get the 204I advantage, taking advantage of that.
Nizar is on a TN visa and filed his I-485 application a couple months ago, and is asking if his TN expires before he gets his green card, can he switch from TN to E2? Probably not. So for the E2 visa is similar to the TN in that it doesn't allow for immigrant intent. So they do review immigrant intent at the E2 change of status or at the consulate pretty closely. So you probably won't be granted an E2 visa now that you've had your I-485 application pending. But I would say your main option is probably going to be, so you said your TN is expiring in March 2026. And if you just filed the I-485, hopefully you filed the I-765 and I-131 EAD advanced parole applications concurrently with your I-485 application. If you didn't, file them now because that's going to be your main option for continued work authorization beyond March 2026 if your green card is not issued by then. So once your I-485 application is filed, the pending I-485 does authorize you to remain in the U.S. separate from a visa status. So even if your TN expires in March 2026, if the I-485 is still pending at that time, you can remain in the U.S. based on that pending I-485. But you won't be able to work unless you have an EAD card, which you can get by filing for it based on the pending I-485. And in order to travel outside the U.S., you would need an advanced parole document. So if you haven't filed for those, file for them now because they can take about 6 months to be issued.
Question from Ruchi, kind of follow-up question is it hard to get 204I getting approval? No, absolutely not at all. It's fairly simple if all the things are ticked properly, that you provide the death certificate, you provide the marriage certificate, you prove that you are staying in the United States. I can't imagine a denial. There is no formal application process. That's a little bit deficient in that, but it is very unlikely to get a 204I denied. Very unlikely. second.
So we have a question about someone who was selected in this year's H-1B lottery. They're on their F-1 OPT, but the petition has not been filed yet, and they're asking should they consider premium processing. It's up to you. Premium processing isn't as necessary as it was before for F-1 visa holders, because even if you're so the main thing you need to make sure of is if you're on an F-1 OPT and if it expires before June 30th, you need to make sure your employer files the H-1B petition before your EAD expiration date. The overall deadline is June 30th, but if your OPT expires before June 30th, that becomes your deadline for filing the H-1B petition. But if your OPT doesn't expire before June 30th, then the company just needs to file it by June 30th. And then from there, while it's pending, you can continue on your OPT. So the cap gap this year has been extended. It used to only extend your work authorization to September 30th. It now extends it to March 31st of 2026. So premium processing is less necessary, but if you are able to afford it, we still recommend premium processing just to get your application approved, while H-1B processing right now is still relatively normal.
Question from Deshi Booker. His I-140 is approved with company A, and it's been more than 6 months. Now he's moving to company B. Is it necessary that to get an I-140 approval now with company B? I'm assuming that you're from India. I'm assuming that your priority date is, let's say, anywhere after 2021 onwards. I don't see a need for you to get an I-140 approval right now with a new company. You can wait maybe a couple of decades. I mean decades. I mean, each decade is 10 years, so you can wait for a couple of decades, at least 20 years, to try to get an I-140 approval with the company that you're working, because I don't think so the priority date is going to move that fast. So no need to hurry up. Nizar has this question. He came into United States on TN visa 18 months ago, and he filed a 485 application. Do you see that as a problem because he came on a TN visa? No, I don't see that as a problem. If your entry was in the past 2-3 months, that definitely would have been some cause to be concerned. If it's 18 months, people can change their opinion. After 90 days, they can change their opinion. I don't see any problem in that at all. One thing I'll tell you, Nizar, right now is that you do not travel unless you have an advance parole. And if you travel with an advance parole, that is suicidal. Not a good option at all. But otherwise, I don't see any problem in your green card. The only thing is make sure you travel outside the country only after you get an advance parole.
We have a question about the H-1B cap petition and travel and the cap gap. So that is something that you have to be very careful about. If you are in F-1 OPT and are having your H-1B petition, you were selected and it's being filed before June 30th, consult with your company and your immigration attorney before you travel this summer. Because if your application was filed requesting a change of status, and if it is pending at the time you depart the US, the change of status request will be considered automatically denied because you left the country while it was pending. The H-1B petition overall can still be approved. You can still be approved for H-1B classification, but if the change of status is denied due to your departure from the country, that means even if it's approved, the H-1B status won't automatically go into effect on October 1st, the way it would if the change of status was approved. You can still activate it by traveling, for example, to Canada or Mexico, even with an expired visa stamp and coming back in, but you would need to, plan to make that additional step and that additional trip in order to activate the H-1B. So definitely consult with your immigration attorney if you have travel plans this summer and you have an H-1B petition being submitted in the cap.
Gopalakrishna has this question that if the green card holder or legal permanent resident want to go outside the country for more than 1 year, What are the options available? First thing, if you can avoid it, please. Um, Definitely, you can file a re-entry permit. It's called I-131 form that you can file a re-entry permit and stay up to 2 years outside the country. But this will create some problems for your citizenship at a later date. I would recommend that you apply for the reentry permit, but actually not use it. And I want you to come back every 180 days because there are some problems that you will face at a later date for citizenship and maybe for other things too. So definitely, I want you to consult a lawyer, see what is better, and I want you to make that even though even if you get a re-entry permit, though, I still want you to travel within 180 days because it makes much better in the long sense. When you consult an immigration lawyer, that guy will explain you why traveling, even though you have a re-entry permit, traveling within 180 days is a better option.
Gayatri's 6-year H-1B limit, including recapture time, is going to expire in June 2026, and her perm application is about to be filed by her company is asking what are the options to extend her stay in the United States. So if your company can file the perm application before the exact 1 year mark, like if your 6-year limit, including recapture time, is June 15th, for example, try to get your company to file that perm before June 15th. Even if it's June 14th, that's fine. Once it is filed at least 1 year before your 6-year limit expires, you're eligible for an additional 7th year extension of your H-1B status. And then if you do travel later this year, of course, if you don't have a visa stamp, we don't recommend traveling. But if you travel between now and next summer, you would be able to recapture that additional time too, plus request the additional 7th year extension. And that will hopefully give enough time for the perm, which is taking about 15 months right now, to be approved. And then for the I-140 to be approved so that your company can file another extension before June 2027. And that would be hopefully the 3-year extension based on your I-140 approval at that point.
Some questions on the adjustment of status. Sudhir Reddy is asking the question whether adjustment of status EAD, how long the person can be unemployment. The answer is you cannot be unemployed. You may be risking your green card if you're unemployed, assuming that you are the main applicant and you're not a dependent. Dependents, it's a different question, but the main applicant definitely cannot be unemployed. It's going to be risky. Also, I got a couple of questions with regards to, have you noticed more denials in the 485? I definitely will say yes, we have seen some denials, but is the rate very alarming at this point of time? The answer is no, it's not alarming. Have you seen any more interviews right now as compared to percentage of? The answer is no. I haven't seen percentage of interviews going up at this point of time. So it's very similar to what it was before. This question, the final question on the 485 that I'm going to be speaking is Jagadish Dulapati has this question. He was an EB3, then he interfiled to EB2. It's still pending. Now EB3 is current. What is the process involved in it? EB2 485J is not approved. I still want you to file a EB3 485J supplement again, and if possible, file the medicals with the I-485J supplement. We sued recently for some of the cases where the practice date was current and they didn't give the green card, and we requested, hey, why are you not giving the green card? And the lawyers of the government said, hey, your guy applied for EB2. We're considering him under EB2. Since the last request was EB2, they're saying that your guy is on EB2 and EB2 is not current. So you can't request me to approve the green card application. Then we realized that it's better to file I-485J supplement and they say, hey, we want it in EB3, make a formal request in it. So definitely if the EB2 is not current and EB3 is current right now, you should request with an I-485J supplement for EB3. Now the question that pops up is, I am not working with the company that filed the EB3. Can I still use the EB3 I-140 approval? The answer is fairly simple. Yes, you can.
Amjad is asking, can a dependent stay beyond 240 days after the I-94 expires if the extension has not been approved? Yes, if the extension application is still pending for some reason more than 8 months beyond the I-94 end date, technically, yes, they can stay. The 240-day rule applies to work authorization for work visa holders when their I-94 is expired. They can work for up to 240 days beyond that based on the pending extension application. But for dependents, they're considered in a period of authorized stay, I guess, indefinitely while the I-539 application remains pending.
Any other things, Rebecca, before we close?
Nope.
Thank you guys for tuning. Thank you, Rebecca, for coming in. For those people, if you want to speak with me, Rebecca, or anybody in our office, our schedule is available at rnlawgroup.com. You just go there, you have a consult. All our schedule is available. You can block a time that suits to you. And please tune in every week so that you get the updates. This is an ongoing thing. So we do bring in current updates every week at Tuesday from 5 p.m. to 6 p.m. Central Time. We take all live questions. That's where we answer all these questions in the past 1 hour. Thank you guys for tuning in.
Thank you.